Good afternoon, Your Honour. This is case number ICTY 367, Rule 77.4 in the matter of Vojislav Šešelj.
Thank you, Mr. Registrar. Good afternoon to everyone. Mr. Šešelj, are you hearing me in a language that you understand?
I am hearing you in translation into the Serbian language, which is the only language that I understand. Here they have been inventing some new languages, Croatian, Bosnian, and what have you, but I only understand the Serbian language, and I shall not allow my native tongue to be insulted by being designated BCS or some similar designations.
Well, inasmuch as you do understand me, do I take it that you represent yourself at this initial appearance today?
Yes, I shall be representing myself also in all coming cases regarding contempt. I have planned another 7 cases, another 7 proceedings to take place for contempt of court, in addition to this one.
I see. Well, notwithstanding that you may have heard this before, I would begin by reminding you that you enjoy the right to remain silent at all times during these proceedings. And I will begin by briefly outlining the background to this case and the charge contained in the order in lieu of indictment issued against you, which for simplicity I would refer to as the indictment. On the 24th of July 2009, in case number IT 0367R772, the Chamber found Mr. Šešelj guilty of contempt for knowingly disclosing confidential information pertaining to 3 witnesses in a book, and sentenced Mr. Šešelj to a term of 15 months imprisonment and ordered him to remove the book from his website. During the course of the appellate proceedings in that case, the Chamber ordered Mr. Šešelj to remove several confidential filings, as well as the book, from his website. On the 3rd of August 2010, the Office of the Prosecutor filed the urgent motion under Rule 77 concerning violation of orders of the Appeal Chamber before the Appeals Chamber, seeking, among other things, an order in lieu of indictment against Mr. Šešelj for violating the orders of the Appeals Chamber to remove the confidential filings and the book from his website. On the 15th of October 2010, that part of the Office of the Prosecutor's motion was referred to this Chamber. On the 31st of January and the 17th of February 2011, this Chamber issued orders in case number IT 0367R773, ordering Mr. Šešelj to remove various confidential material from his website. On the 31st of January 2011, this Chamber issued an order in case IT 0254 miscellaneous.4, also ordering Mr. Šešelj to remove confidential filings from his website. On the 9th of May 2011, this Chamber issued the confidential decision on failure to remove confidential information from the website, noting that each of the filings and books that Mr. Šešelj had been ordered to remove pursuant to the orders of this Chamber and the Appeals Chamber remained available on the website, and initiating contempt proceedings against him for knowingly and willfully failing to comply with the Chamber's orders. The indictment was appended to that decision. Mr. Šešelj, according to the indictment, you are charged with 1 count of contempt of the tribunal, punishable under Rule 77A and Rule 77A2, for knowingly and willfully failing to comply with the Chamber's order to remove confidential information from the website. At this point, I would invite you, Mr. Šešelj, to formally identify yourself by name and how otherwise you are known and identified.
I'm Dr. Vojislav Šešelj, university professor and the greatest enemy of the tribunal at The Hague.
Thank you. Is there anything else you wish to add by way of identification?
Well, there are many things that I could state. For instance, that I'm the only indictee who managed to tear apart the ICTY, that the ICTY has lost all moral and professional credibility in the proceedings conducted against me. I could talk all day long about the results and the successes of my 9-year-long struggle with the tribunal at The Hague. I'm not sure that you are prepared to listen to all that, Your Honor.
Thank you. Mr. Registrar, again, would you be so kind as to read out Articles 20 and 21 of this tribunal statute?
Yes, Your Honor. Article 20. Commencement and conduct of trial proceedings. Number 1. The trial chambers shall ensure that a trial is fair and expeditious and that proceedings are conducted in accordance with the rules of procedure and evidence, with full respect for the rights of the accused and due regard for the protection of victims and witnesses. 2. A person against whom an indictment has been confirmed shall, pursuant to an order or an arrest warrant of the International Tribunal, be taken into custody, immediately informed of the charges against him, and transferred to the International Tribunal. 3. The trial chamber shall read the indictment, satisfy itself that the rights of the accused are respected, confirm that the accused understands the indictment, and instructs the accused to enter a plea. The trial chamber shall then set the date for trial. 4. The hearing shall be public unless the trial chamber decides to disclose the proceedings in accordance with its rules of procedure and evidence. Article 21. Rights of the accused. 1. All persons shall be equal before the tribunal, International Tribunal. 2. In the determination of charges against him, the accused shall be entitled to a fair and public hearing, subject to Article 22 of the statute. 3. The accused shall be presumed innocent until proved guilty, according to the provisions of the present statute. 4. In the determination of any charge against the accused pursuant to the present statute, the accused shall be entitled to the following minimum guarantees in full equality. A. To be informed promptly and in detail in a language which he understands of the nature and cause of the charge against him. B. To have adequate time and facilities for the preparation of his defense and to communicate with counsel of his own choosing. C. To be tried without undue delay. D. To be tried in his presence and to defend himself in person or through legal assistance of his own choosing. To be informed if he does not have legal assistance of this right, and to have legal assistance assigned to him in any case where the interests of justice so require, and without payment by him in any such case if he does not have sufficient means to pay for it. E. To examine or have examined the witnesses against him and to obtain the attendance and examination of witnesses on his behalf under the same conditions as witnesses against him. F. To have the free assistance of an interpreter if he cannot understand or speak the language used in the International Tribunal. And G. Not to be compelled to testify against himself or to confess guilt.
Thank you, Mr. Registrar. Mr. Šešelj, would you confirm the information that I have that you are in receipt of the indictment in your own language?
Da, dobio sam optužni.
Yes, I have received the indictment, but it was as far back as on the 12th of May. So I can see that this provision of the statute is not being honored, namely that there should be no delays in my trial. It was on the 9th of May that the indictment was issued, and it was submitted to me on the 12th of May, so that some 2 months have already elapsed, in fact, for this initial appearance of mine to only take place today. It was not scheduled, Mr. Hall, within a reasonable period of time.
Your observations about delay are noted, Mr. Šešelj. Now, you have the right to have the indictment read out in its entirety, or you may choose to waive that right. Which do you prefer? What is your choice?
Gospodine Hall.
Mr. Hall, I waive none of my rights. I insist that the indictment be read in extenso, so that the public could see what it is that the tribunal does, because the public is quite aware of what it is that I'm doing, but it is not aware exactly of what it is that the tribunal is doing.
Well, bearing in mind the public interests in this matter, I am going to invite the registrar to read out the public version of the indictment.
Yes, Your Honor, the order in lieu of an indictment. Vojislav Šešelj, born in 1954 in Sarajevo, Republic of Bosnia and Herzegovina, and currently on trial before the tribunal, is charged with one count of contempt of the tribunal pursuant to Rule 77A and 77A2 of the rules as detailed below.
Please slow down for the benefit of the interpreters.
Sorry. Vojislav Šešelj was ordered to remove various documents revealing confidential information about a number of protected witnesses from case number IT 0367 from his website. The documents to be removed included 3 books authored by Vojislav Šešelj and 5 filings made by him in case number IT 0367T, case number IT 0367 Rule 77.3, and case number IT 0367 Rule 77.2a. Vojislav Šešelj acknowledged receipt of the Appeals Chamber's decision and the Chamber's orders to remove the confidential information from his website on 5 January 2010 and 2 February 2011 and 21 February 2111 respectively. As of 9 May, the 3 books and the 5 filings remained available on Vojislav Šešelj's website. The charges. By his acts and omissions, Vojislav Šešelj committed contempt of the tribunal, punishable under this tribunal's inherent powers and Rules 77A and 77A2 of the rules, for knowingly and willfully interfering with the administration of justice by failing to remove from their website confidential information in violation of orders of the Chamber.
Thank you. Mr. Šešelj, the rules provide that in proceeding...
Please slow down for the interpreters to finish the reading. Thank you very much.
That under Rule 77E, you would be called upon to enter a plea of guilty or not guilty on each count of the indictment within 10 days from the initial appearance. Under Rule 62A3, you may decide to immediately enter such a plea. And I also need to point out to you that should you fail to enter a plea at the initial appearance or any further appearance, the trial chamber under Rule 62A4 shall enter a plea of not guilty on your behalf. So my question to you now is whether you are prepared to enter a plea today.
Gospodine Hall, za ovih 9 godina
Mr. Hall, over these 9 years, I never was a factor who procrastinated proceedings against me. The proceedings were delayed either by the OTP or by the trial chamber. I am ready to enter a plea today, and I say that I'm not guilty. At the same time, I challenge the right of the Tribunal at The Hague to conduct proceedings for contempt against me, because contempt of court proceedings absolutely cannot be conducted for an indictee accused for the gravest crimes, and not in the common law system or in the continental system either.
Thank you. So we have noted that you have entered a plea of not guilty. I'm sorry, my microphone was off. To remind you that you are, of course, it is open to you, of course, to change your plea at any later stage of the proceedings. I return to a matter that I raised at the very beginning, and that is the question of legal representation. Is it the position that you are representing yourself? Would you be so good as to confirm that?
Da, ja sam.
Yes, I represent myself in this case as well.
Well, I am to remind you that self-representation is a qualified right under the statute, and the rules provide that the trial chamber may, if it decides to do so in the interest of justice, instruct the registrar to assign counsel to represent your interests. Now, again, under the rules, within 10 days of this initial appearance, you shall be provided, in a language that you understand, copies of the supporting material accompanying the indictment. On the 23rd of May, you signed a procès verbal indicating that you received 16 documents which were referred to in the Chamber's decision on failure to remove confidential information from the website of the 9th of July 2011. Additionally, the Chamber hereby directs the registry to provide the accused with its Rule 33B submission dated the 24th of June 2011, as well as the annexes thereto, within 10 days from today. And I remind you, Mr. Šešelj, that these materials are to remain confidential. I am also to remind you that preliminary motions under Rule 72A are to be filed within a 10-day period once you have received all of the supporting material in accordance with Rule 66. Mr. Šešelj, are you in a position today to say how long you would need to prepare your defense?
Ja sam odmah spreman za...
I am ready for the trial right away, but there is a problem, Mr. Hall. Whether that problem is solved or not, I am prepared for the trial. You can schedule the trial as early as tomorrow. I sent a letter to the registry on the 13th of June in which I informed them that in this third case against me for contempt of court, I shall be representing myself. and that I have designated Master of Juridical Sciences Dejan Mirovic as my legal advisor, and Nemanja Šarović, Bachelor of Jurisprudence, as my case manager. I requested the registry to make it possible for my legal advisor and for my case manager to visit me immediately prior to my initial appearance and to be present today in the courtroom. I ask that the registry, to that effect, pay the traveling expenses. You know that there is a decision by the trial chamber in the main case to the effect that the registry shall finance my defense as of the day of the adoption of that decision to the tune of 50%, which would normally be assigned to the defense of the accused, who has an assigned defense counsel. I am contesting this decision of the trial chamber, but it has gone into effect, and the appellate chamber has confirmed it, so that the minimum which was to be observed by the registry was to pay the traveling expenses of my legal advisor and my case manager in order for them to visit me and to attend this initial appearance of mine here today in the courtroom. Yesterday I received a letter by Anna Oshur, deputy of the Legal Assistance and Detention Affairs Unit, and she said in connection with my letter that they have taken a note of the fact that I shall be assisted by Mr. Mirovic and Mr. Šarović, but none of the two gentlemen can be allowed access to confidential materials or privileged communication. But we are talking about my legal advisor from the main case, who does already have privileged communication with me and with whom I can establish daily telephone communications by a safe telephone under number 9. So he already has privileged status in the main case. He also had such status in the two previous contempt of court cases, and all of a sudden now he does not. Nemanja Šarović has been my case manager for a long time, also in the main proceedings conducted against me, and also was that in both cases for contempt of court. They say that the registry should make all the necessary basic checks with positive results. That yesterday, on the 4th of July, in other words, they received the results of the basic checks, and given specific issues that raised, they were in no position to admit Mr. Mirovic as a privileged legal advisor until they received additional information. As far as Nemanja Šarović is concerned, in connection with his status, they are still, or namely the president of the tribunal has still not reached a decision pursuant to my appeal, which I filed many months ago, which has to do with his status both in the main proceedings and in these contempt of court proceedings. In the end, they say that I'm not entitled to financial resources as financial assistance in this case, and nor to the traveling expenses of my legal advisors. In addition, and I quote, the registry has not been satisfied that the initial appearance justifies deviation from the guidelines of the registry, especially in the absence of an order by the trial chamber for the attendance of your associates in the courtroom. Mr. Hall, in all civilized countries in the world, it is the basic right of the accused to have, at the initial appearance, his legal advisor sitting at his side, whether as defense counsel or legal advisor. That is the fundamental right. And they are denying that right to me here. That is why I demand that the trial chamber that you are a member of immediately adopt a decision rule in this case and order the registry to honor the privileged status of my legal advisor, Dejan Mirovic, and my case manager, Nemanja Šarović. and to make it possible for them to visit me within reasonable intervals of time for the duration of this process. I was never unreasonable in that sense, and I was never visited by my advisors more often than once a month, even in the main proceedings. And in these secondary proceedings, perhaps it will be necessary for them to visit me once or twice during the entire case to assist me. The fact that I have decided to self-represent does not literally mean that I have to be alone. The fact that I am self-represented means that I am the first and the main, the principal in my defense team, but I have to have assistance. In some cases, I have to have investigators, etc. In this case, I probably should not be requiring any investigators. I had a problem in the last case of contempt of court. I brought 10 witnesses. I asked the registry to make it possible for me to prepare, to prove those witnesses. This registry prevented Mr. Mirovic and Mr. Sharovic from coming. I never prepared those witnesses at all, in any way. That is scandalous. No matter what the first instance judgment may be in this process, it has to crumble before the appellate chamber when I tell them that I had not been given the chance to prepare my witnesses. These are things which actually discredit the tribunal much more than I myself am able to discredit it in the courtroom. The tribunal is discrediting itself the most, very often because of the cavalier attitude of the registry. That is why I'm asking you as a pre-trial judge and the trial chamber that you are a member of to make it possible for me in preparing the main trial to be able to communicate under privileged conditions with my legal advisor and with my case manager, and for the tribunal to defray their traveling expenses.
Thank you. Of course, the trial chamber is obliged to resolve such matters as remain unresolved and which are properly before it, as distinct from those matters which are within the sole domain of the registry and which have, at the other end of the spectrum, not been resolved at the appellate level. So we've noted everything that you would have said today, Mr. Šešelj. Are there any other matters that you wish to raise before we take the adjournment?
Well,
Mr. Hall, I would like to raise two issues. The first question has to do with the conditions of detention. I am placed on the floor of the detention unit where immediately after his isolation was abolished, General Ratko Mladic also arrived. We socialized with him, we played chess, we spent time with him. However, the day before yesterday, he had his further initial appearance, and he refused any possibility of being represented by anyone from the list of the registry and insisted on exclusively his two chosen defense counsel whom he trusts. And today the decision arrived that General Mladic should be moved from our floor to some other floor, whatever. It is not of consequence within the same building. And this decision was motivated by the assumption that General Mladic, by socializing with me and playing a lot of chess with me, came under my influence, and that I actually influenced him to refuse all the attorneys on the list of the tribunal and to insist only on Milo Šaljić, an attorney at law from Belgrade, and Professor Alexander Mezyayev from Moscow, whom he both absolutely trusts. A certain Alexander Alexić was tried to be imposed on him and some other people. It is true, I did say to him, you cannot absolutely have any confidence in anyone from the list of the tribunal.
Apart from the obvious fact that the arrangements at the detention center are entirely the responsibility of the governor of the detention center, my question was I thought you were talking about that you had a complaint in terms of your own detention, if you would confine yourself to that.
Pa to sam hteo da vam...
Well, I was about to explain that, Mr. Hall. I am personally frustrated by such behavior. I have some feeling of guilt that Mr. Mladic actually had to be moved on my account. That is what frustrates me. And a frustrated person can not adequately defend himself in court proceedings. I have to steer clear of any frustration. Secondly, as you are perhaps the only judge with whom I shall be communicating as of this July until the summer recess of all of the tribunal generally, I demand, this being the 9th year that I've been in detention, to be also granted annual leave.
Is there anything else that you wish to raise?
Pa ovo je dovoljno.
This will suffice, and I am raising this question of my annual leave before you because probably I will not have any contacts with the trial chamber in the main case until the closing arguments. This was announced in their last decision, and who knows when that will be. So I am asking you to grant me annual leave, and many indictees here have been granted annual leave, and that was actually the term used in decisions when they were granted provisional releases. Haji Hasanovic, the Muslim indictee, and Kubura. Kubura were these two gentlemen were given such leaves.
I was going to ask for your assistance in explaining, for the purposes of the record and so that the registry would fully understand what your application is, what you meant by annual leave. But did I understand you to mean what is otherwise referred to as provisional release? Is that what your application is?
Pa da, u tom ga kontekstu koristim.
I'm using it in that context, and I invoke the fact that that expression was already used for provisional releases in the Haji Hasanovic Kubura case. That decision also stated that they were being given annual leave for a month. Please bear in mind the fact that I have been here uninterruptedly for 8 years, and that this has violated all world standards as to the length of detention.
Naravno, postoji da...
Needless to say, there is also the fact that no one can guarantee for me. The only guarantee for me can be me, myself. But you have to deal with that problem. These rules say guarantees must be provided. There is no one that can provide guarantees for me, so there is a legal lacuna there. But you, as the judge in charge, must deal with that legal lacuna in keeping with general legal principles. What if someone is in no position to be provided any guarantees by anyone? I'm not going to ask for guarantees from the treacherous pro-Western regime in Belgrade. I have no one else to turn to, and I have been here for an accumulated period of 8 years of detention.
Could you assist me in this regard, Mr. Šešelj? Should I interpret what you have said orally and without previous notice to be your application for provisional release, or do you intend to file a formal motion seeking provisional release? Did you understand my question?
Nikak, shvatio sam, gospodine.
I understand, Mr. Hall. I understand fully. I will file no written application whatsoever. You know that in proceedings, an oral application uttered in the courtroom has the same legal force as a written motion. This has been recorded, and it's up to you to decide.
Yes, I understand that. I just wanted to be clear that what you said constituted your oral motion, so the chamber is now seized of it. Thank you, Mr. Šešelj. And with that, we would adjourn these proceedings to a date to be fixed. Thank you.
All rise. Veuillez vous lever.